further hearing in the appeal calling on the application of HC and the Secretary of State for Work and Pensions and others.
Yes, Mr. Chairman.
My Lady, my Lords, I set myself 7 hopefully short tasks to be completed in the time that I have remaining. They are first to take your Lordships and my Lady to 2 short passages in an article by Charlotte O'Brien, the most important of which is concerned with the concept of reverse discrimination, as it doesn't apply, we say, in the context of this case. The second is to touch on what we say in the printed case about Ibrahim and Texera. Thirdly, importantly, to deal with Dano, and we'll learn from Mr. Coppell's point that there is binding authority that social assistance is outside the competence of the EU and exclusively within the competence of the member states. A glance at the Family Reunification Directive.
Which directive?
Family Reunification Directive. Simply, it's a very short point, but next to answer my Lord Wilson's point about what the approach was to Section 17, there's one Court of Appeal case, which court should be aware of. Justification in accordance with our printed case, and finally just the basic references to the domestic law on best interests. I hope I can deal with that all relatively shortly. If I could ask your Ladyship and my Lords to look at the Charlotte O'Brien article first, that is Authorities Bundle 5, tab 82, starts at MS 2871. And there were 2 passages that I want to highlight. The first starts at the last paragraph on MS 2873. It was towards the beginning of the article. And this is the reverse discrimination point. And the court will see that she says, an equal treatment line of argument triggers the reverse discrimination question should allegations of discrimination be dismissed because member states retain the right to treat their own nationals detrimentally compared to other EU nationals. I suggest that reverse discrimination is a red herring. Member states are entitled to treat their own nationals not subject to EU law less well than it treats EU nationals. This is the wholly internal rule. However, Zambrano children are within the scope of EU law. They are therefore covered by the general principles of EU law, including the general principle of equal treatment. Now, that basic thought we've picked up and put in our printed case. We are dealing, as I've been at pains to emphasise, with a class of UK nationals whose position is not within the exclusive competence of the UK. That's the basic thrust of the Zambrano line of authority carried over into Marin and the other cases. And so accordingly, one is creating, we say, by the approach the UK government has taken to social assistance, a class of UK nationals who are, we say, being discriminated against because they are in a position governed by EU law. That is not the traditional reverse discrimination position, which is dealing with the position of UK nationals who are not within the scope of EU law because they've never moved. And normally the fact they've never moved is a total answer to the discrimination point, but it isn't in a Zambrano case. And your Lordships and my Lady will see that at the end of the passage, just over the page, MS 2874, there's a paragraph that starts, if there is any substance of the rights attaching to union citizenship, those rights must include equal treatment. The UK should not be allowed to unilaterally modify an EU citizen-based right to reside. and goes on to say if Zambrano is not an obsolete empty right, inferior to other possible statuses pre-existing in national immigration law, it cannot be a license to discriminate against own nationals because they are exercising an EU citizenship-based right to reside. And then it goes on to talk about the adequacy of the Section 17 payments and so on, which I'm not concerned with here. But that's the basic thought on reverse discrimination. It's not the line on reverse discrimination that was put forward by the Advocate General in Zambrano. That was a much more complicated and rather different analysis. This is a simple analysis, which isn't actually reverse discrimination at all, and we say it is correct. So the second passage is one we've set out in our printed case, and I do no more than point to it where it's to be found. 2878. There are two paragraphs in the centre of 2878, the bulk of which we've actually set out in the printed case, so the court may have seen them already, but essentially saying that the creation of the skeletal right on the United Kingdom's thinking about it all, created by Zambrano, is making the same mistake as was made in the Baumbast, Ibrahim and Texera line of authorities. That is an attempt to find within Luxembourg authorities a condition of self-sufficiency when there simply wasn't one. So Baumbast was self-sufficient, Mr. Baumbast was self-sufficient, but it didn't follow that there was any condition of self-sufficiency when one came to consider the position of Texera and Ibrahim in the later cases. And the court will see that the article ends, the paragraph in the article ends just at the end of the second full paragraph. Texera and Ibrahim are to Baumbast as Sana is to Zambrano. And all of that, we say, is correct. And it's
I'm so sorry, I didn't quite know what that means, Mr. Drabble.
What it means is that what she's saying, rightly or wrongly, is that what is happening in Sana, which is the Court of Appeal case, yes, HHC, is the finding of conditions effectively present in the right of residence created by Zambrano, which are simply not there.
Thank you.
That's the thought. We've set it out in our printed case, the bulk of those two paragraphs. I go to those two paragraphs because they're short and make points that we wish to make, but the whole article plainly bears scrutiny. We recommend it to you. Now, that's my first task. The second task was just to take your lordships of Milady to Ibrahim and Texera, as we have explained it in the printed case. We have dealt with this line of authority in paragraphs 428 to 440 of the printed case at MS 109. If the court will go to that. What we have done in paragraphs 430 through to 439, in essence, is effectively try to walk the reader through the structure of the Ibrahim judgment in order to come to the conclusion which we set out in paragraph 434, MS 109 434, where we submit that, having gone through the walk-through process, as it were, it can be seen that the reasoning process of the court was to examine the material relevant to the existence of the right of residence and then to consider whether it was subject to any condition of self-sufficiency. It did not feel it necessary to consider whether there was any positive right to claim social assistance in the absence of such a condition. The whole approach proceeds on the basis that if there is a right of residence which arises even if the individuals concerned are not self-sufficient, the individuals who are exercising the rights derived from EU law will be able to claim the same benefits as nationals of the host state. Unsurprising, given the situation of both the parents and the children are in situations regulated by EU law and within the scope of the anti-discrimination principle and the Charter. And then paragraph 436, we draw the court's attention to the way Lady Justice Arden dealt with this matter in paragraph 77, which was to explain Ibrahim and Texir on the basis that the court had got there by a process of construction of the Citizenship Directive, so that, she says, all of this is part of the code. The code was a long acronym. We say that's simply not right, and we can't, I'm not going to spend time on my feet this morning, but if you carry out the exercise that we've invited the court to do and reading through, it's not a process of construction of the Citizenship Directive, it's predicated on the basis that the Citizenship Directive has no relevance. We're outside the scope of the directive. We simply get to the position that there is no condition requiring self-sufficiency. And just for the note, the key passage in Ibrahim, which we've done the walk-through exercise with, is to be found at MS 1559 to 1562. It's Authorities Bundle 1C, tab 19, the key passage being MS 1559 to 1562. So I don't intend to spend any longer orally on Ibrahim. There are lots of diversions in that case law, but that's the essential thought that we wish to put forward.
Yes, what it's saying is that if you have a right to be educated, you have by implication a right to reside in order to be educated.
Yes.
There's no self-sufficiency.
And there's no self-sufficiency requirement. And we say, by parallel here, you have a right to be present in the United Kingdom to protect the position of the United Kingdom national child. Axiomatically, there is no self-sufficiency requirement, because that's the very nature of the dispute in Zambrano itself. So, learned friend is looking for some other limitation, we would say.
Yes, but he's not saying there's a self-sufficiency requirement. He says,
well, he can't.
No, so
yeah. I mean, so the question for this court is whether there's whether one simply just gives effect to the right of residence on the first of our grounds in the way we put forward, or you say, well, it's sufficient that you're not being forced out, that's enough, and the inquiry ends there.
I'm not sure that I understand why you say, as I think you do, that this amounts to the imposition of a condition of self-sufficiency. I mean, HC is entitled to payments under Section 17 at a minimal level, that's right.
Yes.
But it's not the same as making her right of residence subject to a condition of self-sufficiency. Her right of residence is established, nobody is challenging that, and Zambrano is authority for the proposition that she's entitled not to be treated in a way that would effectively force her out of the EU. But where does this implicit condition of self-sufficiency come in? It's not
No,
there, as far as I can see.
Let me make it plain. In my case, it's axiomatic that her position is not subject to a condition of self-sufficiency.
Well, I see that, but why does that advance?
And so the question then is there any limitation on any other limitation on her ability to claim benefits, or is it simply sufficient that you provide the minimum amount that doesn't force a departure?
Well,
that's the issue in the case.
Is the issue. I can't see how it helps to discuss an implicit condition of self-sufficiency.
Part of the problem I had quite a lot of yesterday afternoon and today is I'm dealing with the way in which the judgment in Mr. Koppel's case is put against me, which is that all of this is governed by the code of EU secondary legislation, which is an exhaustive code. And the moment you go there and you don't find any entitlement to social assistance, that's the end of the matter. But that doesn't stand up for the reasons I'm trying to explain. Now, I mean, I completely agree. One has got to somewhere that is not all that surprising. One has got to a situation where the position of the Zambrano carer is not covered by the code, because as we've seen repeatedly in the authorities, their position is within the competence of the EU, although not covered by the secondary legislation, and one has to go on from there. We find that again, if I come now to Dano, which is at bundle 1B, tab 17, it starts at MS 1450. And the key passage starts at 1490. The point of going to this is that my learned friend says that if one looks at the answer to question 4, which one finds in paragraphs 85 to 92, starting at 1494, I don't know if everyone points to paragraph 90, which says, accordingly, since these conditions result neither from Regulation 883/204, which is the General Social Security Harmonisation Regulation, or from the Citizenship Directive 2004/38, or other secondary EU legislation, Member States thus have competence to determine the conditions for the grant of such benefits. They also have competence, as Advocate General Waterloo said, observed in point 146 of his opinion, to define the extent of the social cover provided by the type of benefit. Consequently, 91, they are not implementing EU law when they lay down the conditions for the grant of these benefits. Now, the point that we make in the note is that conclusion, 90 and 91, is against the background of the whole of the passage, answering questions 2 and 3, which start at 1490. And we again have dealt with this in our printed case at MS 112, paragraph 4.45. And once again, we've tried to highlight the main aspects of the relevant passage in paragraph 4.45, but essentially what it does is to treat the Citizenship Directive as laying down conditions subject to which the primary rights in Article 18 and 21 take effect. So the treaty rights are subject to the conditions laid down in secondary legislation. the secondary legislation says that if you're economically inactive, you don't have a right to equal treatment. That's the essential reasoning if one works through the detail of paragraph 4.45. So the conclusion, my submission, rather unsurprising conclusion at the end of the day, was that Mrs. Dano, who was economically inactive, had no right to any social assistance derived from EU law at all. If you go back to the judgment itself, paragraphs 70 through to 74 make precisely that point. So the foot of MS 1491. Through to 74 is the court holding that in the first 3-month period of residence, the member state, the host member state, is not obliged to confer entitlement to social benefits to a national of another member state or his family members. It's the last sentence of paragraph 70. So no EU right during that period. And when one goes on to 73, you're dealing with people who are economically inactive residents, again, inactive citizens again, resident for longer than 3 months, you come to the same conclusion. Because their right to be present in the host state is subject to the condition in the Citizenship Directive that the court describes in the last sentence of paragraph 73. The conditions include the requirement that the economically inactive union citizen must have sufficient resources for himself and his family members. So by the time you get to the answer to question 4, we know that Mrs. Dano doesn't have a right derived from EU law to social assistance. That's what we've been told in the answers to questions 2 and 3. She could be given nothing, or she could be given something, but that's a matter entirely for the member states. It's not a matter for EU law because the conditions in the secondary legislation drive the main treaty obligations in Article 18 and 20. But as we say in the printed case, that analysis has no relevance to a Zambrano carer because they do have, the whole point is, they do have a derived right of residence, derived from the treaty itself, not subject to any limitations contained in the secondary legislation, because they're outside the scope of the secondary legislation. That's what the case law says time and time and time again. So we respectfully submit that paragraphs 90 and 91 of Dano have got nothing to do with this case. The unavoidable conclusion is that when the member state makes provisions such as Section 17 available, and the member state relies on the availability to say it's complying with the obligations in Zambrano, it is implementing European law. As we say in the note, all of this is compatible with the principal authority referred to in paragraph 88 of Dano, which is Aclagaran. And our note came with Aclagaran attached. and it treated the issue of whether European law was being implemented as a scope issue, and don't necessarily ask the court to look it up. We referred to the principal paragraph in our note. The principal paragraph is paragraph 21, which is to the effect that the fundamental rights guaranteed by the Charter must therefore be complied with where national legislation falls within the scope of EU law. Therefore, situations cannot exist which are covered in that way by EU law without those fundamental rights being applicable. And we've seen time and time again the court saying that the position of the EU national child and the carer are within the scope of EU law, and despite the fact that the member states have competence normally to define who can come in and who can be kept out, and therefore to set boundaries to their ability to support themselves, that competence is not exclusive when it comes to the position of the EU national child and the carer. That's the whole point of the doctrine. Just applying paragraph 21 and 22, the reverse, the proposition and the reverse of the proposition of Aclagaren referred to in 88 of Dano, we know we are dealing with a situation that is within the scope of EU law. So that is Dano. The next port of call is the final submission on the code, the allegedly exhaustive code, is just to ask the court to look at the Family Reunification Directive to see whether the existence of this directive, and one could repeat the exercise with all the others that my learned friend relies on, demonstrates that you approach the position of the Zambrano carer on the basis there is an exhaustive code dealing with social assistance entitlement. I say that basic proposition is misconceived, and if you pick up the Family Reunification Directive, which is at Authorities Bundle 2, tab 45, MS 2068. Yes, it starts at 2068. Simplest way of making my submission is it is doing no more than domestic legislation did in the case of MM, which is the case that this court decided about financial requirements, whether or not you could have a 16 or 18,000 or whatever the figures were, financial requirement to allow the spouse to join husband in the UK or whichever way around it was. It's doing absolutely no more than that. It's predicated on the basis that a degree of family reunification may be necessary to comply with Article 8 of the European Convention and indeed the relevant article of the Charter of Fundamental Rights. The court will see that from recital 2. On page 2068. Article 4 provides the basic obligation to authorise the entry and residence pursuant to the directive. That's 2070. Subject to compliance with the conditions laid down in Chapter 4 of then the list of family members are set out as conditions laid down in Chapter 4, which is important for this purpose. The conditions laid down in Chapter 4 include those in Article 7, which one will find at 2071, where the application for family reunification is submitted. The member state concerned may require the person who submitted the application to provide evidence that the sponsor has, and then there's a list: accommodation, sickness insurance, stable and regular resources, and so on. So it's very similar to the minimum financial requirement provision that was in play in the domestic case of MM. It's doing no more than that. What is its relevance to a Zambrano carer whose situation plainly has never been contemplated by the community legislature? It simply hasn't addressed the issue. We say very little, but we say none, actually. Zambrano carer plainly doesn't have to comply with these conditions, and his situation is simply not regulated by this Code of Secondary Legislation. So that's my point on the Family Reunification Directive. As I say, one could repeat the same sort of point on all the components of the code. Lady Justice Arden set out in the paragraph I think I took your ladyship and my lords to yesterday, but they're all vulnerable to the same analysis. So that's the point on the Family Reunification Directive. Next task is the Section 17 issue. We can best answer Lord Wilson's question by handing in copies of a relatively recent Court of Appeal authority, which is now the leading authority, I think, on carrying out assessments under Section 17. It's called Crown C and Others against Southwark London Borough Council, reported at 2016 Housing Law Reports 36, but here come some copies.
Thanks.
This is a case, first of all, can I just say there's something confusing about the report, because the leading judgment, the report says, was given by Lord Justice Moore-Bick, who later is recorded as agreeing with himself, but he didn't, because the leading judgment was actually given by Lord Justice Ryder, who is the senior president of the tribunals. And if your ladyship and my lords look at page 3 of the report.
So we should substitute Ryder LJ for...
Yeah, absolutely, and the whole thing makes sense. Once you've done that, it works. The nature of the dispute was an allegation by Mr. Cooper and myself that the London Borough of Southwark had acted unlawfully in providing for a quantum of assistance under Section 17, which was the equivalent of child benefit rates for the children. So we say you have a family of adult and children, what is being provided is number of children times family child benefit rate. That's self-evidently a misuse of the child benefit rates because they're not a subsistence benefit. Now, Lord Justice Ryder said, well, the evidence doesn't support that Southwark has an inflexible policy But if you're just simply asking what is the quantum of the payments that are made, the quantums of the payment that were being made were, in fact, as a matter of fact, exactly identical to the child benefit rates. That's the point. Subject to some accommodation on top of that, and also bus passes, some other non-financial. But the basic quantification of the cash payments came out the child benefit rate. And if the court looks, first of all, at page 7 of the report.
Well, paragraph 12.
Yes, exactly.
Yep.
There's a passage, I won't read it, and I don't know whether the court wants to take time reading it now, but the passage describing the legal machinery, as it were, what Section 17 is about, is paragraphs 12 through to 15. And essentially what was happening, and what Lord Justice Ryder said was lawful in Southwark, was a assessment from time to time of the needs of the family, which required my client to draw up a shopping list of essential needs, which are sometimes pruned down and sometimes met in whole, but which in fact turned out to be the child benefit rates. Can't complain about the second bit now, but it's a periodic assessment of the basic shopping basket, how a family needs to get by on. That's what's happening in practice. As your ladyship said yesterday, and the first sentence of paragraph 12 says, that's all acceptable because we're not dealing with a specific or mandatory duty owed to an individual child. And if one picks up the quote in paragraph 14, Mrs. Justice Dobbs in Blackburn, Smith and Lambeth, the indent, the defendant's powers under Section 17 were never intended to enable it to act as an alternative welfare agency in circumstances where Parliament had determined that the claimant should be excluded from mainstream benefits.
It's not a benefit scheme.
It's not a benefit scheme. That's exactly when
The benefit scheme, like income support, is intended to support people at subsistence level. The homelessness scheme is intended to prevent people with certain conditions becoming homeless. Section 17 was never designed for that.
Yes.
It was designed principally to stop children having to be taken into care
Yes.
in circumstances where their parents were struggling to look after them.
Yes. And essentially what happened in this case is that my submission that it was wrong to use child benefit as the quantum was rejected because that was converting it into a benefit scheme. You say, effectively the court said to me, well, you're looking for a particular quantum. Well, we've actually got a series of assessments saying that the children are well fed and well looked after, and that's all that needs to happen under Section 17. We don't need to look further for a subsistence income. It's not what it's about. And I just invite the court to read the judgment as a whole.
Thank you.
But I think that's the best answer I can give.
I'm grateful to you.
Can I just get some idea of quantum from the facts in the head note? Just on page 2, I won't take them through, but you will see fairly small weekly sums being paid from time to time and varied from time to time depending on the circumstances.
And it's all basically discretionary, both as to whether...
And it has a peculiar relationship, I say not peculiar relationship, but perfectly straightforward relationship given its purpose with charitable payments and payments from relatives and other means of support. Now, all of that's entirely understandable given its purpose. It is being converted in the whole of the Secretary of State's case here into the way of ensuring that, to use the words of Zambrano, the family, the carer, has sufficient resources. It's not what the scheme is actually about, other than ensuring that the welfare of the child isn't unacceptably harmed. That's Section 17. The last task is the submissions that we make on the justification case, which we have dealt with in our printed case at paragraph 460 Roman 1 to Roman 5, at MS 115 to 117, and what we have done here, I think I took the court yesterday to paragraphs 115, 116 of Lady Justice Arden's judgment. We have picked up each of the matters said to justify the treatment. She, of course, was proceeding on the basis that the only issue was the European Convention on Human Rights, and therefore dealing with a manifestly without reasonable foundation test. But in any event, these are the elements said to justify the discrimination if we get there. First of all, finance, which we deal with in the first Roman 1 and Roman 2. We say that basically, following Ministry of Justice in O'Brien, you can't use finance alone. You can't just save money by discriminating. You have to explain why the group is being singled out. And then Roman 3 and then Roman 5 deal with two other elements in the alleged justification. One is that it's sensible to put limits on public spending by concentrating funds on those with the greatest connection with the United Kingdom. I submitted yesterday that the justification runs contrary to the whole grain of Zambrano. You have a EU national child, a doctrine designed to prevent him or her from having to leave the territory of the European Union. Why does that show a lesser connection with the United Kingdom than other individuals? It simply doesn't, in our respectful submission, stack up. And similarly, there's a deterrence provision. Perhaps it is worth just looking at what Lady Justice Arden said about deterrence, which is in paragraph 116 at MS 2117, so just slightly further on in the core volume. Paragraph 116 is referring to the part of Mr. Cooper's evidence, which is that a purpose of the structure of the UK scheme, its reliance on Section 17, is to deter people from having children unless they already have the resources to support them. And as we say in our comment on that, that runs counter, was crisply counter to the dicta of Lord Hope in ZH Tanzania, at paragraph 44. I won't turn it up now, but if one turns up 40, I think it's 43 and 44.
Well, if the parents are being deterred, you shouldn't
penalise a child.
Shouldn't penalise
That's
the
a simple thought. Yeah. I mean, for your note, your court will find ZH Tanzania at Authorities Bundle 3, tab 64 at MS 2371. And in essence, those are my submissions. It's possible to further elaborate the best interest point by reference to well-known passages in JS, the benefits cap case, and Matheson. But I anticipate the court, or at least some members of the court, are extremely familiar with those. So I won't go there now.
Two of us are.
Good.
Could you just, I mean, to what extent is Article 14 of the ECHR in play?
Well, it is in play.
And if so, how do you formulate it in those two
Well,
sentences?
no, it's in play because if for some reason I fall outside scope of
Yes, so
implementation,
but how do you
of the law,
formulate your case on that?
then the justification.
Yeah, how do you form who's being discriminated?
Oh, I see.
What status?
Right, right.
And in respect of what convention right?
It's within the ambit of Article 8. It is also within the ambit of A1P1, but I don't think that matters. It's within the ambit of Article 8. We have given, we have given in our printed case the references in Carmichael. If your lordships of my lady look at page 118.
Yes, that was the bedroom tax case.
That's the bedroom tax case. Yes. Basically what's happened with the ambit of Article 8 is that in the benefit cap case, Lord Dyson accepted that the restriction on housing benefit and income support present in the was within the ambit of Article 8. That has now been put beyond doubt. If you need anything beyond the judgment of the Master of the Rolls, in Carmichael, at paragraph 49, that's what we say in paragraph 465 at MS 118.
They were in the scope of Article 8.
Yeah.
Yeah.
And the people who are being discriminated against are, just as in EU law, both the carer and the child. I took court yesterday to the part of our printed case where we say it's artificial to look at these benefits that are being provided solely for the claimant.
By reason of what status?
By reason of their immigration status, but I prefer to put it by reason of their status as a Zambrano carer. That's a sufficient status for the purposes of Article 14. It's a very clear status in accordance with the approach the court took in Matheson, for example, to the position of disabled children.
Well, Zambrano carer and caree.
Exactly.
Not sure that's a word.
Well, whatever.
So their Zambrano status under EU law gives them is sufficient to bring them into the scope of Article 14.
Yes.
Okay. And then the question of justification, where you rely on the same
Yes.
grounds as you.
I mean, the fact that it's Zambrano status under EU law is an accident. If it was some other immigration status which put them in a different category, and you then irrationally or...
No, I mean, I understand you put it, it's just, it wasn't very clearly formulated in your case.
Well, that's probably fair.
Thank you.
That is the way I put it. Unless I can...
Just to follow that, could you in a sentence explain how you put your discrimination case in EU law? What is the relevant prohibition of discrimination?
Relevant prohibition of discrimination is within Article 21 of the Charter. We have put it in the printed case. It's a prohibition on the basis, the status of immigration status is the same as in the list of prohibited matters within Article 21, but we have exactly the same submission as I've just made in relation to Article 14. But it may actually be better to look at it not as a broad immigration status, but as a sharper focus for EU law, because you're singling out, as we've just seen in the Charlotte O'Brien article, a category of residents in the UK who are here simply, who are depending for their legal rights on their EU status, and that group is being discriminated against.
You submit, do you, that Carmichael is a comparable case, because Carmichael engaged Article 8 because it was about the ability of people to accommodate for example, disabled relatives in their house or flat. I mean, that has a much more obvious resonance in Article 8 than the simple level of social security support.
Well, with respect, that's even if one, I don't accept that that is the explanation in Carmichael, because the benefit cap case was also held to be within the ambit of Article 8. But even if one looks at just housing benefit as the mode of expression of support for the home, that's the simplest analysis, which I must have put forward more times than I care to remember, really. You start with the proposition, what is the ambit of Article 8? You have a cash benefit like housing benefit that is the state's means of expressing support for the need for the family to have a home. That brings it within the ambit. See Petrovich and I think an Austrian case on paternity allowances. Apply that here, you have a denial of housing assistance, a denial of housing benefit, substitution of a different means of support via Section 17. That actually does have very extreme consequences of the housing for the family. You'll see that if you look at the facts of C, that C had to move because of the whereabouts of the Section 17 support completely out of London, away from the school, into provisions in the north of England. That all is within the ambit of respect for the home, a fortiori, in fact, on the benefits cap case. Lord Toulson's comments in Carmichael don't contain any lengthy analysis of why it's within the ambit of Article 8, but my submission is that's because it's obvious that we are within the ambit of Article 8 once you look at the consequences of denial of the benefits.
Thank you very much, Mr. Drabble. Mr. Kumar? I assume that Mr. Banner comes next.
I believe that's right, my lady. May I start firstly by thanking the court again for the opportunity to address you, and secondly, unsurprisingly enough, by adopting Mr. Drabble's submissions. The point that I'd like to develop briefly is the financial aspect of the relationship of dependency which the Zambrano principle seeks to preserve in the EU, and how that assists Mr. Drabble's analysis. You'll find that point, I don't want to need to turn it up, but you'll find it in my printed case, paragraphs 4 to 7, MS 150. And my entry point for this, my lords and lady, is MS 132, Mr. Coppell's printed case for the Secretary of State, paragraph 24, where he advances a broad statement of principle that the Court of Justice, in applying the Zambrano, is avowedly concerned with residence and not economic advancement. And I take issue with that and respectfully suggest the better formulation in the light of the cases, and I'll come to those in a moment, is as follows, that in defining the circumstances in which the Zambrano right arises, the Court of Justice is avowedly concerned with dependency and not economic or family advancement falling short of dependency. It's avowedly concerned with dependency and not economic or family advancement falling short of dependency. And understood thus, the proposition doesn't assist Mr. Coppell or the Secretary of State. And the reason I formulate it in that way is that all the cases on which the Secretary of State relies are cases where the court was looking at whether the right arose in the first place. and having concluded that it didn't because there was no relationship of dependency, the court didn't go on to explore what the right entails when such a relationship does exist. The one case where it does look at it is Zambrano itself, and I'll come to that at the end of my submissions because there's a pretty useful clue in Zambrano. Where there is a relationship of dependency, protected by the Zambrano principle, the ability of the carer financially to support himself and his dependent child is something, I say, which the Court of Justice sees as part of that relationship and something which is protected by, or at least within the scope of EU law, the ability of the carer financially to support himself and his dependent child or children. The one case in the line of case law, apart from Zambrano, I wish to take the court to. The other ones I'll simply give you, if it's acceptable, the headline points and the references, is Yemaraga, which is the case that Mr. Koppel relies upon at paragraph 24 of his printed case to support the proposition. That's at 1C, tab 27, MS 1854. and 1855.
Well, you might need to have a Zambrano right of residence, even if you were very rich.
Oh, yes.
Or in
Yes.
employment, or
Yes.
your financial circumstances. I mean, obviously, there may be a financial component to the children not being forced out of the jurisdiction, but nevertheless, the right could arise, irrespective of how rich the carer is.
Absolutely, absolutely. The financial aspect is one element of the relationship. There obviously are other important elements too, such as care and support in the non-financial sense. The point I just want to highlight in relation to Yemaraga is a rather complex set of facts, but the EU citizen in that case, who is a national of Luxembourg, you see reference at paragraph 14 on MS 1855, Kreshnik. He was an adult at the time of the claim, not a carey, an adult. You see that at paragraph 11. The case concerned whether his parents and brothers who weren't EU citizens were entitled under EU law to a residence permit in Luxembourg. You see that at paragraph 15. And far from him being dependent on them, he'd actually made financial contributions to them. In fact, one way the domestic court had looked at is whether they were dependent on him. And you see that at paragraph 17. So critically, this wasn't a case where the EU citizen was dependent on a third country national, but rather he desired, understandably, to bring his family into the EU for other reasons. And that was the context for the passage that Mr. Koppel relies upon in paragraph 24, namely that a desire for family or economic reasons to reunite one's family in the EU isn't enough. There has to be a relationship of dependency. The passage within the report is at 1857, 1858. Starts at the bottom of 1857, paragraph 38. So the court has also found in this respect the mere fact it might be desirable for economic reasons or in order to keep the family together for members of the family who don't have nationality of member state to be able to reside with him in the territory of the Union is not sufficient in itself. So that was the point that the court was making in Yemaraga, not the broader proposition that Mr. Koppel suggests, namely that economic considerations have nothing to do with the right when it arises. Turning from Yemaraga, there are three other cases in the line of case law you haven't been taken to. As I said, if it's convenient, I'll simply give you the headline point of the reference, because all I'm doing is effectively saying these cases aren't relevant, don't assist. So O, the Finnish case, it's Authorities 1C, tab 22, MS 1664. And that was a case about the child's mother's second husband, who exercised no parental role for the child in question, of any kind, financial or spiritual. The child was dependent on the mother, wasn't dependent on the father, and therefore the father had no Zambrano right. See AG 45 and AG 48, Advocate General Bott at MS 1672. And it's notable that the Advocate General, as I say in my printed case, appeared to ascribe some significance to the child's financial dependency on the mother. He saw that as forming a significant part of the relationship with the mother. And then CJU paragraph 56, expressly adopting the AG at MS 1688. EDA, if that's how it's pronounced, which is the next case, authorities 4 tab 69, MS 2495. That was a case where the applicant father had separated from the child's mother, and he was in fact claiming a right to reside in a different country from where they lived. He was claiming a right to reside in Germany, and they'd moved to Austria. And whilst there was some ongoing co-parenting, on the facts the child didn't need the father's support because she already had the support of a carer, was dependent on the carer, namely the mother. So again, it's a case where simply the court found there was no relationship of dependency as opposed to what that relationship entailed. In the last case, McCarthy, which is 1C, Bundle 1C, tab 21, MS 1638, was a case where there was no child at all. It was a husband and wife situation, and the court found that, again, the relationship of dependency didn't arise, unsurprisingly. So, pulling that together, as I prefaced this section of my submissions, what the cases establish is that in order to trigger the Zambrano right, it's necessary to do more than show that it would be desirable from an economic or family or any other perspective for the EU citizen to have his or her family members with him. The citizen must be dependent on the family member in question. But what the cases importantly don't hold, crucially for this case, is that where there is a relationship of dependency, economic factors are irrelevant to it, or that the extent of the right conferred on the carer is limited in the way that the Secretary of State suggests, and so therefore they simply don't assist the court on this issue. However, Zambrano does, as I said, give a clue as to the extent of the right when it does arise and the extent of the relationship, and appreciating that the court's been taken to it. Could I ask the court to turn it up? It's at 1C, tab 24, MS 1809. The passage that I'd like to draw attention to is paragraph 44. We're having set out the basic rationale behind the Zambrano principle. The court didn't simply stop at saying that the principle confers a right to reside. It also significantly, I'd suggest, went on to say that it confers a right to work. And why did it do that? See just above letter H. If a work permit were not granted to such a person, then I underline the next words, he would risk not having sufficient resources to provide for himself and his family.
Which would result in the children having to leave the territory
Of the EU.
That's a critical point, isn't it?
Yes, well, my lord, the answer to that is threefold. Firstly, paragraph 90 of the Court of Appeal's judgment, where Lady Justice Arden explained why, whatever the right is, one doesn't wait till the departure or the imminent departure from the EU. One recognises that the consequences of insufficiency of resources, albeit she calibrated that by reference to section 17, that the consequences can be taken, can be assumed, and therefore the right arises at the earliest stage. I also highlight the word risk above H as well, which is anticipatory. And similarly for your note, Advocate General Sharpston, at paragraph 99, talks about sooner or later, quote unquote, sooner or later, they will have to leave the EU. Paragraph
But
17.
Mr. Banner, if the court here is saying without a work permit they may well have to leave, the court doesn't seem to have been thinking that there was another avenue which might prevent their having to leave, namely a general social security entitlement.
What I suggest, my lord, is that the point simply wasn't an issue in that case, which is in fact agreed with Mr. Coppell, but the point I simply highlight is that the mischief, which is not having sufficient resources to provide for the family, is not a mischief that could only arise by not having a legal right to work. It's a mischief which could arise by having a legal right to work but not having work.
Of course, the Advocate General did, in her presentation, deal with whether, if somebody like Mr. Zambrano was to have the right contended for, he would become an unreasonable burden on public finances. And no doubt you know this. These paragraphs, they start at 118 and go on to 121 on pages 1786 to 1787.
Yes.
And so she wrestles with, well, is this going to be an unreasonable burden on public finances? And then she says, well, this man's been working somehow in Belgium for 5 years, paying national insurance contributions, that and that sort. So you really can't say in that sort of situation that he's going to be an unreasonable burden on public finances, which rather indicates, arguably, that she was dismissing the idea of social security coming to the aid of the party in a situation like this.
Well, in the domestic law regime in Belgium, the situation we find ourselves in wouldn't have applied because the domestic law regime, once he had a right to work, gave him the parachute in any event. But, my lord, the critical point is that rationale doesn't follow through in the Court of Justice's analysis. And the simple point I make, I don't say that this passage is definitive, but it's a clue, is that the sufficiency of resources that the carer has to provide for himself and his family is something which the EU considers is relevant to the Zambrano principle within the scope of EU law. And the factors my lord identifies are, if they are in play, they are matters for justification as opposed to matters for considering the scope. But the sufficiency of resources reference must indicate in my submission that the court considers that the financial aspect of the relationship is within the scope of EU law. And if that's right, my lord, then how does that then fit into the structure of the argument before the court? And I'd suggest there are two ways of looking at it. Either the pure Article 20 analysis, which is that Article 20 entitles the carer to a level of financial assistance which gives them sufficient resources to provide for themselves and their child, and in that context, sufficiency should be judged by what the state considers is appropriate for its own citizens to provide them with subsistence level support. So that's the pure Article 20 approach, which that's issue 2 in the SFI, and then the discrimination approach in the alternative, which is in calibrating the level of assistance to be provided to enable the carer to have sufficient resources to provide for themselves and their family. The state is implementing EU law. And that's really the point Mr. Drabble makes at paragraph 4 of his note, that there's a choice, because it seems to be common ground that something needs to be done. The choice taken by the state is section 17. The choice of that, as opposed to some other measure, is within the scope, thereby engaging Article 51, the Charter. That brings into play Article 21 on discrimination, and the relevance in my submission of the best interest, Article 24, is that in considering any justification for discrimination within the scope of Article 21, the best interests must feature as a primary consideration. So says Article 24. So Article 24 is relevant in the context of Article 21 there. So there are two ways of looking at it. They're ultimately two different routes to the same destination. But in my submission, that observation in paragraph 44 of Zambrano at least suggests that our approach is arguable, which even if the contrary is arguable, that is, in my submission, all that we need at least to justify the making of a reference.
So do you say that either of those routes is act clear?
It would be a struggle for me to say
would be a
it's
struggle.
clear. So, no, like Mr. Dabble, I accept that a reference is going to be likely. But that, given that the one indication the court has given as to what the right means when it arises, as opposed to how one assesses whether it arises, but given the one indication that the court has given is this, which at least is a stepping stone along the way to the argument we put forward, I do say that Mr. Coppell's case against us is not that clear. My lady, my lords, that's all I wish to say by way of elaboration of, obviously, Mr. Drabble's points, which I adopt in their entirety.
Thank you very much.
Thank you very much.
Thank you, my lady. The case for the defendants can be summed up in three propositions. To start with those. Firstly, as a general rule, third country nationals, and I may call them TCNs for short, are not entitled to claim social benefits. That is the position in both domestic and EU law. Secondly, the effect of Zambrano is to confer an exceptional right upon a TCN to live and work in a member state. The Zambrano right does not itself depart from the general rule, Proposition 1, and does not itself confer any right upon TCNs to claim social benefits. Thirdly, it is lawful for the Secretaries of State to make regulations to maintain and confirm the position that TCNs who can claim the exceptional Zambrano right to live and work are not, as a result of Zambrano, entitled to claim social benefits in the UK. Now, I'm going to elaborate on those three propositions in the remainder of my submission. So I have 6 sections. Firstly, I'm going to deal with the position before Zambrano, both under domestic and EU law. Secondly, I'm going to deal with Zambrano itself and subsequent cases which shed light on its meaning. Thirdly, I'm going to take you briefly to the legislation which is under challenge in this case to show you what it does. Fourthly, I'm going to address issue 2, which was Mr. Drabble's first submission, that there is an automatic right to social benefits flowing from Zambrano. Fifthly, I'm going to make submissions on issue 1, the discrimination contrary to EU law issue, and sixthly, and finally, I will deal with the ECHR. As a matter of terminology, as I deal with these points, I will use the term social benefits to refer to the benefits which are the subject of the 3 sets of regulations which are before you. These are all non-contributory benefits funded out of general taxation. They are mostly safety net welfare benefits, which are classed as social assistance in the Court of Justice case law. They also include family benefits, child benefit and child tax credit, which the Court of Justice regards as social security. But you will have seen from the explanatory memorandum yesterday that TCNs are not excluded by these regulations from contributory benefits. So, for example, old age pension, contributory job seekers allowance, contributory employment and support allowance, provided, of course, they make the contributions and meet the other conditions. So we're not concerned with contributory benefits. So then, what was the position before Zambrano? Under domestic law, the general position was and is in section 115 of the Immigration Act 1999. That's volume 2, tab 33, MS 1900. Immigration and Asylum Act 1999. Section 115.1, no person is entitled to universal credit, income-based job seekers allowance, state pension credit, and so forth, or to various other benefits, including child benefit, under the Social Security Contributions Benefits Act 1992, while he is a person to whom this section applies. Who does the section apply to? Subsection 3 on 1901. This section applies to a person subject to immigration control, unless he falls within a prescribed category. What is a person subject to immigration control? Subsection 9 is a person who is not an EU national and who requires leave to enter or remain in the UK but does not have it, or has leave to enter or remain which is subject to a condition that he does not have recourse to public funds, and a couple of others. But this is essentially third country nationals. Their entitlement to benefits is excluded by section 115. That was the position in general for TCNs, that is the position, and Mr. Drabble does not challenge it as contrary to EU law or to the Convention. Now, this rule is an aspect of immigration control, and you saw Mr. Drabble took you to Mr. Cooper's statement, paragraph 13, and I'll just give you the page reference, page 454 of Appendix 2, MS 644. And that's the paragraph of his statement where he makes clear that this is an aspect of immigration control. And there is, make no mistake about it, a serious immigration problem at issue here. Mr. Cooper also says, that's paragraph 23 on MS 648, and again you were taken to it yesterday, he says that the typical Zambrano carer is an individual who came to this country as a visitor, overstayed illegally, entered into a relationship whilst their immigration status was precarious with a British national, and then had a child, or children, as in HC's case. That is the typical situation of a Zambrano carer, and it is HC's situation. She was an illegal overstayer. See paragraph 1 of Mr. Justice Supperstone's ruling. She married while legally overstaying and then had children, and she falls precisely within the immigration problem which is adumbrated by Mr. Cooper. Now, the domestic law position, section 115 of the 1999 Act, is entirely consistent with EU law. We say EU law takes exactly the same approach in general to the position of third country nationals. First of all, we know, and it is now common ground in these proceedings, that EU law does not prohibit less favourable treatment of third country nationals. Now that follows from Article 18 of the Treaty on the Functioning of the European Union. And if I could ask you to open bundle 1A at tab 8, and it's page 1103, MS 1103, Article 18, within the scope of application of the treaties and without prejudice to any special provisions contained therein, any discrimination on grounds of nationality shall be prohibited, and it is the words within the scope of application of the treaties. If you move forward in the same bundle to tab 11, Patman Nietzsche case, My Lady's judgment, paragraph 83 at page 1183, My Lady cited what was then Article 12 of the EC Treaty, now Article 18, the words that I've just read, and at letter G on the page says, this is not a general prohibition of discrimination on grounds of nationality, only the nationals of member states are protected. So that's 1183. Only the nationals of member states are protected. Discrimination against third country nationals is not prohibited. Indeed, it is positively expected. The underlying purpose is to promote the object of the union, and in particular free movement of workers and free establishment of businesses, and so forth. Some other instances and some other indications that EU law does not prohibit less favourable treatment of third country nationals, including in the area of social benefits. You have the Race Discrimination Directive, Bundle 2, tab 43, and that is at MS 2058. And Article 3.2 in the right-hand column, this directive, which lays down a framework for combating race discrimination, does not cover difference of treatment based on nationality and is without prejudice to provisions and conditions relating to the entry into and residence of third country nationals and stateless persons, and to any treatment which arises from the legal status of the third country nationals and stateless persons concerned. You also have in the following tab, and I won't go to it, but the Framework Directive on Discrimination, which contains a similar exclusion in Article 3.3 at MS 2064. And in our printed case, at paragraph 27, subparagraph 2, on MS 134, we set out a series of directives which relate to third country nationals, which confer limited rights of residence and give limited rights to social benefits in certain circumstances. I'm not going to go to any of these, but we rely in particular on the long-term residence directive at Roman 2. Mr. Drabble took you to the Family Reunification Directive. Now, why am I showing you, why am I asking you to consider the various bits of secondary legislation they're described, which don't even bind the United Kingdom, incidentally? Why am I asking you to consider those? Well, Mr. Drabble made lengthy submissions yesterday based on Zambrano and the subsequent cases to the effect that they do not address and say nothing useful about his primary case, that the Zambrano right carries with it a right for the third country national to claim mainstream social benefits. Mr. Banner continued in that vein today. They say, and it's as far as their case goes, that the Court of Justice case law does not assist you on the question of whether third country nationals have a right to social benefits flowing from Zambrano. Now, I say that the cases go further, and they show that the Zambrano right is limited in its scope, but I also say that you have to look at Zambrano in context, and the context, as a matter of EU law, is that third country nationals have no general right to social benefits. And none of this secondary legislation could stand if there was a general underlying right somewhere for third country nationals to have social benefits. So I'm not saying that this is an exhaustive code, that there's no scope for any rights outside these directives. Plainly, Zambrano is such a right. But what I do say is that the context plainly shows that the general position is that third country nationals have no right to social benefits, and that one would need very clear words in Zambrano or subsequently to assume that the Court of Justice intended to depart from that general position. Now, the domestic law position, section 115, is also consistent with the ECHR. Mr. Drabble concedes that it is. The leading case on third country nationals' right to social benefits under the ECHR is Barr against the UK. That's 1C tab 28 MS 1860. I'm going to go to it. The general approach is wide margin of discretion, as you'd expect. Wide margin of discretion, allocation of scarce resources, which groups have priority and which don't in the context of immigration control and so forth, is quintessentially the business of government and not of the courts. Now, to complete the picture, I've been discussing the rights of third country nationals to social benefits. The position of EU nationals in terms of rights to social benefits as a matter of EU law, well, that is variable. Paragraph 27 of our printed case, MS 133, we explain the position, and in essence, some EU nationals are entitled to non-contributory social benefits, essentially where they're economically active, and some aren't. And we've gone through a whole series of cases over recent years, culminating in the infraction commission against the United Kingdom, where the Court of Justice upheld the right to reside test for social benefits. We've come through all these cases that we've set out in paragraph 27, and the position is established that EU law confers rights on EU nationals to receive social benefits in some situations, but not in others. And one of the oddities about Mr. Drabble's case is that it asks you to assume that the Court of Justice in Zambrano intended to confer a right upon third country nationals, which is better than that enjoyed by EU nationals, whether or not they're economically active. We say that is an oddity and is one which he simply hasn't addressed. Now, can I hand up a table which we produced to the Court of Appeal, which is a sketch of what I've been saying up to now as to what the general position is for these different categories of individual and their access to social benefits. There are two documents coming. One is about the legislation, and I'm going to come back to that. But for now, it's a one-page table.
Thank you.
So we set out the general position, and as with all these things, there are exceptions, but the general position for British nationals with a British national child, for EU nationals, economically active do have entitlement, inactive don't have entitlement. British national child, and then third country nationals, a third country national with no EU law right, so somebody who's not a Zambrano carer, with a British national child, no entitlement, subject to some exceptions, and that's section 115. Third country nationals under the TCN directives that I've just been talking about, some variable entitlements in the other member states depending on the directive, not in the UK, and then the Zambrano right as a result of the regulations, no entitlement unless within some exception which applies to other TCNs as well. Now, each of these categories has a British national child, and I think the reason why we originally produced this table was that we were fed up with Mr. Drabble saying that the regulations create a special, a unique category of British national child who is discriminated against in access to social benefits. That's simply wrong. Therefore, for better or worse, and under legislation that he does not challenge, the position of his clients, British national children, is exactly the same as that of the British national children of other third country nationals, certain EEA nationals, and so forth. We also produce...
Can you think of a circumstance, I'm sure you can, of a third country national who had no EU law rights but had a British national child?
Well,
Think about that.
Sorry, well, there are routes for such individuals, for example, under Appendix FM, which I'll come back to get leave with recourse to public funds and so entitlement to social benefits. But the general position is, Section 115, no entitlement, whether your child is British national or, as we say at the bottom.
I do understand that. I'm asking for an example of a real case. Perhaps you'd like to think about it. I don't want to put you on the spot, but I'm just trying to work out what sort of people are within your fourth category.
Well, we'll take this, my lady. Take somebody who doesn't fall within Zambrano, and I'm going to come back to this in a bit more detail, but you take somebody, and you'll recall the Chavez case, where the child has another carer, or where the other parent has some care of the child, and the relationship is such that that parent is a viable carer should the mother have to leave the country. In those circumstances, the mother does not have a Zambrano right. She has no EU law rights of residence, and she is in the position in the fourth category. Another case of somebody who just doesn't fall within Zambrano is somebody who has a right of residence in another country of the EU.
Yeah.
So
that was the one I was thinking of. But in both of those cases, the child isn't put in the position of being forced to leave the territory of the EU, which is the situation that we're concerned with.
Yes. Well, in fact, and in this case, in our case as well, the child is not in the position of being forced to leave the EU.
Well, the argument is that if mum were forced to leave, the children would be forced to leave.
Oh, indeed. But on the facts of our case and these regulations, there is a finding, and again I'll come back to this, there is a finding from the lower courts that HC and others in her position will not be forced to leave the EU because of the level of support which is available to them should they need it. And that is a finding which is not challenged, has not been challenged, is not before this court. Now, the other reason for which this table is of relevance is in relation to Mr. Drabble's discrimination claim. His written case performs the somewhat extraordinary feat of pursuing a claim of discrimination without identifying who he says his clients have been discriminated against as compared with. And he was asked that question by my Lord Lord Carnworth earlier today, and he still hasn't answered it. I didn't pick up an answer. Who is he comparing HC's children with, or HC herself with? If he's comparing them with other British national children, well, see this table. Is he comparing them with EU national children? Well, they're in the same position. I just don't understand the case I have to meet yet.
I took it to be a comparison between the Zambrano children and their carers as compared with non-Zambrano children and their carers. Now, whether that's a identifiable status is another question, but that seemed to be the way he put it.
Well, if that's it, then he's comparing line 4 of our table with line 6, and the position is exactly the same. So, I mean, if that's it, then I really don't understand what the problem is.
I think that's the nearest we've come in all the papers, as far as I can know, to a definition.
Yes, well, it's nice to have that to respond at least. So that's the table. Second section of my submissions then, Zambrano itself. It's bundle 1C, tab 24. And I'm going to ask you to note 5 points from the judgment. The first point is what the issue was that the court was deciding. And on MS 1765, this is from the Advocate General's opinion, it gives a slightly fuller explanation. We see facts from paragraph 23 onwards that Mr. Zambrano was employed in a workshop. His work was subject to statutory social security deductions and his employer paid the relevant contributions. But paragraph 24, he didn't have a work permit during the time he worked for the company. At paragraph 28 on the next page, this came back to haunt him when he became firstly temporarily unemployed, and the National Employment Office refused his claim for temporary contributory unemployment benefit because he hadn't had a work permit at the relevant time. And then proceeding down that page, you end up at paragraph 30. Unfortunately, as a result of further inquiries, Mr. Zambrano was sacked for not having a work permit. He then makes a further claim to unemployment benefit, paragraph 31, and again, it's refused on grounds that he didn't have a work permit at the material time. And it is these two refusals of the National Employment Office, which, if you go forward to 1807, and paragraph 33 of the court's judgment, it is these two decisions to refuse him contributory unemployment benefit which are the subject of the questions from the National Court in Zambrano. And the issue you see towards the end of 33 was whether the qualifying period necessary for unemployment benefit had been completed as required by the legislation governing foreigners' residence and employment of foreign workers. And you can see from 1803, we don't need to go there, but from 1803 that legislation required you to have a work permit unless you had a right of residence. So Mr. Zambrano says, paragraph 34 onwards, I don't need to have a work permit, or I shouldn't be required to have a work permit during my qualifying period because I had, at the relevant time, a right of residence under EU law. And just to be clear, because there's often a little bit of confusion in my learned friend's submission, this case is about whether Mr. Zambrano had a right of residence in Belgium, not about the rights of his children. Now, the conclusion in the end, of course, was that he did have a right of residence because of the position of his children. But this case is about his rights, not those of his children. The second point I wanted you to note is in paragraph 42, we have the principle in Zambrano, which is that the underlying principle, which is that Article 20 precludes national measures which have the effect of depriving citizens of the Union of the genuine enjoyment of the substance of the rights conferred by virtue of their status as citizens. And my lady asked Mr. Drabble, well, what does that mean? And Mr. Drabble fashioned a response designed to give the impression that there was some doubt as to what that means. But in fact, there's absolutely no doubt what is meant by depriving citizens of the genuine enjoyment of the substance of their rights in paragraph 42. What it means is the rights in question are their right to live in the EU. And the point being, as we go on to see in 44, that if Mr. Zambrano was not granted a right to live and work in Belgium, he would have to leave and the children would have to leave the European Union. Now, I'm just ask you to leave Zambrano for a moment. We'll come back to it. But this point that it's about living in the EU was made crystal clear in Derecki shortly after Zambrano. That's bundle 1B, tab 18. Paragraph 66 at MS 1530. And Mr. Drabble did show you this yesterday, but this is the straightforward answer to my lady's question. What does paragraph 42 mean?
Could you give me the page reference again?
1530.
I was coughing while you said it. So.
Court of Justice says it follows that the criterion related to the denial of the genuine enjoyment of the substance of the rights conferred by virtue of EU citizen status refers to situations in which the Union citizen has in fact to leave not only the territory of the member state of which he is a national, but also the territory of the Union as a whole. That's what paragraph 42 of Zambrano is talking about, as explained in paragraph 44, and that is why, as the court went on to find in Derecki, because the claimants were under no risk of having to leave the EU if they couldn't bring their adult family members into Austria to live with them, the Zambrano right didn't arise. But that's the answer. Paragraph 66 is the answer to what paragraph 42 of Zambrano means. Third point, and I'm still on paragraph 42, that principle has no application, no purchase in this case, in our case. Why is that? Because the lower courts have found, I made this point a moment ago, have found that Section 17, Children Act support, is sufficient, along with the right to live and work, to prevent Zambrano carers from being forced to leave the UK. And we've set out the relevant passage from the Court of Appeal in paragraph 29 of our printed case. There is no challenge to that. That's not part of the grounds of appeal. And the conclusion that the Court of Appeal drew, that there was no conflict with paragraph 42 of Zambrano, that conclusion is entirely consistent with the evidence in this case. You look at the evidence of HC in this case, she has always said, quite openly, that she has no intention of leaving the United Kingdom. She would wish to have greater support from the state while she lives here, but she's not leaving. Under no circumstances is she leaving. And that is the consistent picture across the category of Zambrano carers as a whole. These are individuals who, by and large, have made great efforts to get to the UK and to stay in the UK, often illegally, almost always illegally. And there is no question at all of them leaving the UK unless they're physically forced to do so. Once they have a right to live here, then of course they won't be physically forced to do so. So we're simply not in Zambrano territory once the right to live and work has been recognised. The fourth point on Zambrano, as Mr. Drabble says, and as I have hopefully demonstrated with my explanation that the case was about a right to contributory unemployment benefit in Belgian law, the case is not about access to social benefits, and the Court of Justice did not directly address that issue. But this court can, in my submission, draw conclusions from the approach of the Court of Justice in Zambrano. Firstly, because, as my Lord Wilson put it to Mr. Banner, the indication in paragraph 44 of Zambrano, the only indication which is relevant to social benefits, Mr. Zambrano needs a right to work, otherwise he won't have the resources to enable him to stay in Belgium. That is a conclusion which is premised at least on an assumption that there is no other state support available to him, at least once his contributory unemployment benefit runs out. But also, and this goes back to the context, that if you place Zambrano in its context, the Court of Justice simply leaves untouched the well-established position that TCNs have no EU law right of access to social benefits. Now, the proper analysis of Articles 20 and 21 of the treaty, which are the basis for the ruling in Zambrano, is that citizens' rights of free movement, the Article 21, take effect subject to conditions and limitations set out in the treaties and secondary legislation. That's what Article 21 says. One of the conditions or limitations, well established, see Article 18, see Patmar Nietzsche, and my lady's point there, is that third country nationals do not have a right to equal treatment under EU law, and they do not, save in narrowly prescribed circumstances, have any right to social benefits. See all the directives that I showed you. So if one's looking for conditions and limitations that might be relevant to the Article 21 treaty right that Zambrano is based on, well, that is a highly relevant condition and limitation, we say. The final point to note, the fifth and final point that I ask you to note from Zambrano, is in relation to Mr. Drabble's submission that the Court of Justice did not impose a condition of self-sufficiency before the Zambrano right could arise. Well, that is, and I adopt what my Lord Sumption put to Mr. Drabble this morning, that point is, and these are my words, a red herring. The Zambrano right granted by the United Kingdom is not subject to a condition of self-sufficiency. HC has it, even though she has the right to live and work in the UK, even though she's not self-sufficient. I'll show you the legislation in a moment. It is an entirely different question. Once you have the right, as she does, do you have any further right to claim the social benefits which are the subject of the regulations before you? Now, on the case law subsequent to Zambrano, there are three features of that case law that I wanted to show you in particular. The first feature is that the Court of Justice and the domestic courts have elaborated upon what is meant in paragraph 42 of Zambrano by depriving citizens of the genuine enjoyment of their rights. And I've shown you directly that it's all about being forced to leave the EU. The Court of Appeal in Harrison, the relevant passage from which is in paragraph 25 of our printed case, applied directly, and we do rely and commend paragraph 67 of the judgment of Lord Justice Elias, which is set out in paragraph 25 of our case. And in particular, in the middle of the paragraph, the right of residence is a right to reside in the territory of the EU. It is not a right to any particular quality of life or any particular standard of living. Accordingly, there is no impediment to exercising the right to reside if residence remains possible as a matter of substance, albeit that the quality of life is diminished. If the quality of life is seriously impaired, that may lead to infringement, but it's not about quality of life. It's simply whether you are able to live in the territory of the EU or not. And the MS reference for that is 1330 for that extract from Harrison. A further feature of the post-Zambrano case law is the Court of Justice making clear, and perhaps is only logical, that the Zambrano right will not arise if, when required to leave the member state in question, the mother, the Zambrano carer, has somewhere else that she can go within the EU. And that's the Alokpa case. I don't think I'm going to go to it. I'm just going to give you the reference. Bundle 4, tab 65, MS 2372. A Zambrano or a putative Zambrano carer living in Luxembourg, father in France, French national children. If she was unable to live in Luxembourg, she could live in France. Therefore, no Zambrano right. Because the children would not be forced to leave the EU if she were denied a right of residence in Luxembourg. And then the other point, and I made these points in connection with the table, the Zambrano right will not arise where the EU citizen child has another viable carer with whom they may live in the EU if the putative Zambrano carer, usually the mother, is required to leave the member state in question. And that's the Chavez case, and there are issues about how you go about deciding who's a viable carer and who's not, but these are, it's a further clear boundary to the ambit of the Zambrano right. So there's been elaboration of paragraph 42. The next feature of the post-Zambrano case law is that far from expanding the scope of the Zambrano right and the situations in which it applies and the benefits that may flow from it, the Court of Justice has, we submit, been careful to limit Zambrano to its specific facts. The cases I've just been discussing are examples of that. Dereki, Ida, Imaraga, Alokpa, all of these are the Court of Justice rejecting attempts to expand the ambit, the scope of Zambrano beyond the narrow facts of the Zambrano case. And the boilerplate wording which one sees now in Court of Justice Zambrano judgments, we've set it out in paragraph 22 of our printed case. It's from the recent judgment of the Grand Chamber in CS, but there's a number of other cases where the same wording is used, and it's in particular paragraph 29 of the CS case, which we've there set out, where the court refers to very specific situations in which, despite the fact that secondary law does not apply, and so on and so forth, the EU citizen may be forced to leave the EU, etc., etc. Very specific situations. And we say that this is unsurprising, given the context in which Zambrano arises, which is the competence of member states to regulate the entry and the residence of third country nationals. Very controversial.
I think this is a passage we adopted in Agiaco.
Agiaco, indeed, yes.
Where there's actually quite a useful summary of the position from Lord Reid.
Yes,
including this passage.
which we also refer to in our printed case. It's paragraph 62 to 66 of Lord Reid's judgment. And we rely on Agiaco for its recognition of the immigration problem and the ambit of discretion which is afforded to the Secretary of State in that case in deciding how to regulate the problem. And the only difference between the facts of Agiaco and the facts of HC and other Zambrano carer facts are that HC had children. The claimants in Agiaco did not have children, but that's the only difference. The immigration problem of illegal overstayers entering into relationships while their status is precarious is exactly the same.
Well, some people might think it's quite a big difference to have children.
My lady, I was just thinking that, and yes, it's a significant difference, but in terms of the immigration situation which leads to the case arising, that is the distinction between Agiaco and our situation. And our case is doubly controversial because it concerns not just rights of entry and residence of third country nationals, but also the provision of social benefits. And we know from the whole line of justice cases that you've been referred to, from Bray to Dano to Alamanovic, Garcinieto, Commission Against the United Kingdom, the Court of Justice recognises that obligations to provide social benefits in those cases to EU citizens, that's a sensitive area which member states are concerned to maintain control over. Now, the final feature of the post-Zambrano case law that I wanted you to note is that in those cases where the Court of Justice has held that the Zambrano right does not arise, therefore has rejected direct reliance upon Zambrano, it has also rejected attempts to reach the same result via the Charter on Fundamental Rights. And just as Mr. Drabble does in this case, common mode of argument. Firstly, we rely on Zambrano. If we can't get home by Zambrano, well, we're within the scope of implementation of EU law. It's the Charter, and there are rights to family life and best interests of the child and so forth, and we can get there through that route instead. And the Court of Justice has rejected that in EDA, first of all, Bundle 4, Tab 69, MS 2495.
And is this discussed in your case?
We have referred to Ida, but not for this particular point, my lord, I'm afraid. So Ida, if one starts at paragraph 23 on MS 2522, this case has really marvellous facts. Mr. Ida, Japanese national, marries a German national in the United States, has a daughter who has German, American and Japanese nationality. They move to Germany, he gets a residence permit. The wife and daughter then move to Austria, and the question arises whether Mr. Ida can have a residence permit in Germany as a family member of an EU national. Discuss. And the answer was more or less he could, but he hadn't applied for it properly. The relevant conclusions, and I just need to canter through these before we get to the end. Paragraph 45, Mr. Ida satisfied the criteria in the long-term residence directive, which was referenced in our case, and you have it in the bundles, and so he could have had a residence permit under that. But 46, he withdrew his application for a residence permit. So doesn't get that. Next, did he have a right as a family member under Directive 2004-38, the Citizenship Directive? Answer, no. See paragraph 65. And essentially that would give him a right to live with his daughter in Austria, but not to live without his daughter in Germany. Next argument, is he a Zambrano carer who can have a Zambrano right to live in Germany? Answer, no. 73 to 76. The Court of Justice makes the perhaps obvious point in 76 that his daughter's right to live in the EU didn't seem to have been impeded by his circumstances, as she was now living in Austria. But then, having failed on all those grounds, Mr. Ida relies on the Charter, and that's paragraph 78 onwards. And there's a question asked, or the German court refers to the Charter, and the Court of Justice recounts in 78 how the Charter only applies to member states when they are implementing European Union law. And then paragraph 79, to determine whether the German authorities' refusal to grant Mr. Ida a residence card of a family member of a Union citizen falls within the implementation of European Union law, it must be ascertained, among other things, and see these criteria then, whether the national legislation at issue is intended to implement a provision of European law, what the character of that legislation is, whether it pursues objectives other than those covered by European Union law, even if it's capable of indirectly affecting that law, and also whether there are specific rules of European Union law on the matter capable of affecting it. Now, one might have thought that German law providing for the issue of residence permits to family members of European Union citizens, one might have thought that that ought to fall within the scope of EU law, but it doesn't. Paragraph 80 is the conclusion, and the Court of Justice concludes that the situation of Mr. Ida is not governed by European Union law because he doesn't satisfy the conditions of the long-term residence directive or the citizenship directive either. And paragraph 81, therefore the Charter is not in play. So quite a narrow approach to whether the member state is implementing EU law.
But Mr. Koppel, I mean, if we ask ourselves, is the situation of this appellant governed by EU law? There's only one answer to that, isn't there?
Yes, and the answer is no.
Well, it depends what you're talking about.
Well, yes, yes.
What the question is. And I was going to ask you how you apply the analogy of this to our case. So in a sense, I was waiting to the answer to the same question.
So the fuller answer to my Lord Wilson's question is that it's the wrong question, or it's not a complete question. In order, and we'll see this from some of the other case law that I'm going to take you to, but in order for the facts of a case to fall within the scope of EU law for charter purposes, they must be both within the personal scope, that is, the individual must be a person who is subject to EU law, and the subject matter of the case must fall within the material scope of EU law. So it's not enough to say, well, I'm an EU citizen, I've got an EU right of residence, I'm a Japanese national who's married to a European citizen, or I'm living in the UK as a result of a right conferred by EU law. That's only half of the question. You then have to ask, well, what particular legislation are you saying is within the scope of EU law? Is the subject matter of that legislation also within scope? And will
Isn't it rather simpler than that? I mean, this is a point I tried to put to Mr. Drabble. If the right of HC under EU law, under the Zambrano principle, is limited to a right to the Section 17 assistance, fallback assistance, then the question whether this country should give greater assistance ceases to be a question of European law.
Well,
I mean, it's a question of gold plating, and gold plating has never been a question of European law, it's a question of domestic law.
yes. Well, I absolutely agree with that, and the next authority that I was going to take you to makes that point. I mean, not quite in those terms, but is strongly supportive of what my Lord...
I mean, that's what's being said here. He doesn't satisfy the conditions. The question whether he should get by even though he doesn't satisfy the conditions of EU law is not a question of EU law.
Yes, and that is precisely the mode of reasoning of the Court of Justice in the Imaraga case, which Mr. Banner referred to, when it comes to deal with charter arguments, and that is bundle 1C, tab 27, MS 1858. From paragraph 40 onwards, and as you know from what Mr. Banner told you this morning, this case is a relatively straightforward Derecki type case where the adult, almost adult EU citizen would like his parents to live with him but won't have to leave the EU if they can't. So he's not a Zambrano case, see paragraph 39. So can he rely on fundamental rights under the Charter, paragraph 40? Criteria, as in EDA, paragraph 41. Finding, paragraph 42. While the Luxembourg law on freedom of movement is indeed intended to implement EU law, it is nonetheless the case that the situation of the applicants is not governed by EU law, since Mr. Imaraga is not a beneficiary under the Citizenship Directive or under the Long-Term Residence Directive, and the refusal to confer a right of residence on his family members does not have the effect of denying him the genuine enjoyment of the substance of the rights conferred by virtue of his status as citizen of the Union. So pausing there, once you've asked the question, is the Zambrano right being respected? Is Zambrano being respected? Yes, it is being respected in Mr. Imaraga's case because he's not going to have to leave. He can stay in the EU. Then you are outside the concern, beyond the concern of EU law, and that's paragraph 43 In those circumstances, the Luxembourg authorities' refusal to grant the family members a right of residence is not a situation involving the implementation of EU law. And that, we say, is the point that my Lord Carnworth puts to me. Once you've complied with Zambrano, so there's no danger of breach of paragraph 42 of Zambrano, anything else you might do as a member state is a matter for you. It's not within the scope of EU law. And the direct read across to our case is, once it is established and accepted as it is, that HC and others like her are not going to be forced to leave the UK, anything else the UK might do in terms of conferring this benefit or that benefit is not the concern of EU law and is not something to which the Charter applies. And I'll obviously come back to that in due course. So that's the post-Zambrano case law. Next section, legislation under challenge. I fully understand Mr. Drabble's reluctance to show you the legislation, as it is complicated. But what we have done is to take a schedule from our Court of Appeal skeleton argument, which appeared in the appendix at MS 322, and reference it to the to your authorities bundles and to the memory stick. So the document entitled "Schedule the Legal Framework," which came with the table some time ago this morning. You should already have it. That's it, my lady.
Yes.
So, so residence regulations, the relevant regulations, the 2006 Immigration European Economic Area regulations, 15A, this is paragraph 2 of the, on page 2 of the note, paragraph 2, 15A, 4A, so going over to page 3, these are the various derivative rights. P satisfies the criteria in this paragraph if P is the primary carer of a British citizen. That British citizen is residing in the UK and would be unable to reside in the UK or in another EEA state if P were required to leave. That is the Zambrano right, and under 15A subpara 1, you have a right of residence if you satisfy those criteria. Now, as is apparent from this, there is no condition of self-sufficiency, and you can compare that with 15A sub 2, which is the Chen right, the Chen derivative right, where self-sufficiency is a condition of the right of residence, 15A 2B Roman 2, but no self-sufficiency condition for Zambrano. If one then looks at how this plays out in the regulations that you are directly concerned with, and taking, as the Court of Appeal did, the DWP regulations as perhaps the best example, starting on page 4 of the note, the regulations amend the right to reside test for entitlement to income support in this case, and some of my lady and my lords will be familiar with the right to reside test from previous cases. I see. The right to reside test is 21AA of the income support regulations, and sub 1, a person from abroad who gets nothing means a claimant who is not habitually resident in the UK or elsewhere in the common travel area. And then sub 2, no claimant shall be treated as habitually as habitually resident in the UK unless he has a right to reside in the UK other than a right to reside which falls within paragraph 3. So, stripping out the double negatives, in order to be treated as habitually resident, you must have a right to reside, other than a right to reside which falls within paragraph 3. And then paragraph 3 sets out various rights where under EU law, member states do not have to provide social assistance. So it's for job seekers and in the first 3 months of your residence as an EU national. And what the regulations that you are concerned with did, see subparagraph 4 on page 7, pardon me, is to add a new right to subparagraph 3, namely the Zambrano right. So you see about halfway down the page on page 7, after paragraph 3b, insert the regulation 15A4A, Zambrano right, and then also the treaty right on which it is based. So to make clear that a Zambrano carer who before Zambrano had no rights because of section 115 of the 1999 Act, to make sure that to confirm the position that they did not acquire a right given the way the right to reside test works, 21AA sub 3 is amended to include the Zambrano right in the list.
Do we need to wrestle with these mechanics, Mr. Coppell?
You don't need to wrestle with them. There isn't any particular issue which arises from them, but I just thought it would be helpful for you to understand what exactly was done, and we've set out what was done in relation to the other regulations. Yes. I mean, there are contextual points that can be made. This all takes place within the context of the right to reside test, which has been before this court in Pat Malnicha, in Mirga and Samin. It's been before the Court of Justice in Commission against the United Kingdom and has passed each test to which it has been subjected. But there isn't any particular issue which arises from the mechanics. I've made the point about no self-sufficiency condition, and I would also make the point in terms of what the new legislation does. And Mr. Drabble says, well, what's happened is it's withdrawing benefits from this special category of UK children who are specially treated and so forth. And of course, it's not. And you saw the explanatory memorandum yesterday. It's not withdrawing benefits from people who had them before. It is confirming the position that they still don't have them, and they will not acquire them as a result of an accident of the way the right to reside test.
Well, I mean, in the sense that when the Zambrano decision came out, there was a category of people who acquired rights which they didn't have before, more extensive rights. This has cut them back, hasn't it?
Well, but for this amendment, yes, they would have a right
that
to reside.
extent, the way he puts it is accurate.
Which was good enough. Well, my Lord, in a whatever the period of time is between Zambrano and the regulations coming into force, but the purpose and the application of the regulations is to people who have not enjoyed benefits in the past, and they will continue in that situation.
In HC's case, she probably never had such a right.
Well, indeed, yes. On the fact she never claimed benefits. In essence, because she was here illegally, or at least thought she was here illegally until Zambrano. Next section is the alleged automatic right to social benefits flowing from Zambrano. Now, I've made a number of the points already in my run through the Zambrano case law, so this should go a little bit more quickly. But Mr. Drabble's first argument is that the regulations are contrary to some right which is inherent in or flows directly from Zambrano itself, this being a right along the lines of, I think he put it, a right to participate fully in the legal life of the country. Now, he in my submission had some difficulty formulating exactly what this right is that he's arguing for. And that's because it's a right that nobody else has ever thought of. And it's not a right which has any support in any of the decided cases, either of the Court of Justice or of the domestic courts. And the idea of a general right to participate fully in the legal life of the country is simply not how EU law works. The way it works in directive after directive, treaty article after treaty article, is to confer specific rights of residence, which may or may not carry with them specific rights of equal treatment, and to equal treatment in some things but not in others. And we could do an exercise of looking at each of the directives you have in the bundles, and here's the right of residence, and here's what you can claim equality in respect of and what you can't. It's different. It's different in each context. Now, the Zambrano right, of course, isn't a right under secondary legislation, it's under the treaty. So what's the right of equal treatment in the treaty? Well, that's Article 18, and that's the right which doesn't prohibit discrimination against third country nationals. So that's a problem for Mr. Drabble. But where is this right supposed to come from? Mr. Drabble accepted yesterday that there is no trace of this right in Zambrano itself. He says he cannot say that Zambrano means that HC must have the full range of social assistance benefits. He said it just doesn't deal with that issue. He also argued that subsequent cases don't deal with the issue either. That, in our submission, doesn't take him very far, nor does it take him very far to show you the domestic law in Spain, see Marin, in Holland, see Chavez, and say, well, it looks like the UK might adopt a different approach. That takes him nowhere in establishing that there is an EU obligation to enable HC to participate fully in the legal life of the country, or whatever the right is. And we say, given the position pre-Zambrano regarding the rights of third country nationals, and the absence, the undoubted absence from EU law of any primary right of equal treatment for third country nationals, that it would take, and I've said this already, it would take very clear words in Zambrano or in a subsequent case to establish that the Court of Justice was intending to depart from that well-established position. And in fact, we say the opposite has occurred when one looks at the subsequent case law. The Court of Justice has made clear the Zambrano right arises only exceptionally, in very specific circumstances. It's a right to reside, it's a right to work, and it only arises, only is of relevance, where otherwise an EU citizen might be forced to leave the EU. Now, Mr. Drabble has an argument based on Ibrahim and Teixeira, borrowed from Miss O'Brien of York University, that in those cases, Ibrahim and Teixeira, the Court of Justice recognised an implicit right to claim social assistance in the UK, and Zambrano ought to be no different. So the argument goes. The problem with the argument is that in both Ibrahim and Teixeira, as a matter of domestic law, and I'll take you to Tejera in a moment, but as a matter of domestic law, because of the right to reside test for entitlement to benefit, whether or not the claimant had a right to the social benefit at issue depended upon whether they had a right to reside. And so the issue that troubled the domestic courts and got sent off to Luxembourg in both cases was whether the individual had a right to reside, not what benefits ought to flow from that. So,
well, that, of course, is exactly the situation in Zambrano.
well, indeed. And that's why
Domestic
Ibrahim...
courts have a problem, they send it to Luxembourg, but they send that problem to Luxembourg, they don't send everything else.
Well, Milady...
I mean, he's saying that the comment you're making about Ibrahim and Teixeira is exactly the same comment that Mr. Drabble might make about Zambrano.
Yes, and just as Mr. Drabble said, Zambrano doesn't help him positively to establish his right because it simply just wasn't concerned with the right of access to social benefits. Well, that's exactly the same point in Ibrahim and Tejera. Domestic law provided for the benefit if you had a right to reside, and the question which the Court of Justice was looking at was whether they did have a right to reside. Can I show you Tejera quickly before the short adjournment? Bundle 1C, tab 19, begins on MS 1537. This report has both of the cases in it. And paragraph 19 on 1589, this is Tejera, and paragraph 19, this is in the court's judgment, it follows from the relevant national provisions that the applicant's entitlement to housing assistance depends on whether she has a right of residence in the UK conferred by EU law. So does she have a right of residence? The right of residence that she relied on was the right of the parent of a child in education. The UK and various other member states argued that that right was subject to a condition of self-sufficiency. She wasn't self-sufficient and therefore she couldn't have it. And the Court of Justice held that that was wrong and there was no condition of self-sufficiency attached to that right. And that's the conclusion in paragraph 61 of Tejera, and a similar conclusion on a slightly different way of putting it in paragraph 70. So she had the right, no condition of self-sufficiency. But that simply doesn't help us in our case. We know that HC has the Zambrano right. We know there is no condition of self-sufficiency for her to satisfy. And so we simply don't understand how Mr. Drabble, and indeed Miss O'Brien, on whom he relies, can argue that Ibrahim and Tejera are any more helpful than Zambrano itself in establishing the wide-ranging right for which they argue. So we say no automatic right from Zambrano, so it's discrimination or nothing, and I'll start with that after the short adjournment.
Thank you very much, Mr. Cotter. We'll look forward to hearing from you at 2 o'clock. Court is now adjourned.